Good morning. Yesterday, that's on the 8th of April, the Supreme Court gave a verdict, landmark verdict. That means it laid down new principles of jurisprudence. It's about the governor's role under Article 200 of the Constitution of India. We have to trace the history of it. How it came to the Supreme Court, what are the articles, what's the grievance of the state of Tamil Nadu, and before Tamil Nadu, Punjab. What did the Supreme Court say? How was it significant? This is our discussion today. Not only what you have come across in the newspapers, much more clearly, of course, and many more details also. So that if you are going for law optional, you are okay, general studies, you are okay, political science, public administration, all of them are taken care of with this lecture. So let's get started. You know, the governor of Tamil Nadu, from January 2000, that is 2020 January, till October 23, he sat on the bills passed by the state legislature and sent to him. And Tamil Nadu comes to the Supreme Court, knocking the doors of the Supreme Court, praying that it intervene and ensure rule of law and compliance with the Constitution. So what's the basis for the Tamil Nadu state to come to the Supreme Court? It came under Article 32, that is the writ, jurisdiction of the Supreme Court. A writ can't be issued to the governor. There is another Union Home Secretary. So the state of Tamil Nadu versus the governor of Tamil Nadu and another, that is the Union Home Secretary. So it's an Article 32 because fundamental rights are violated. How they are violated, we'll see. And they also invoked Article 163 and 200. We'll see all of them. So what was the issue that the Tamil Nadu state brought to the Supreme Court? Tamil Nadu said, state legislature passed the bills, sent to the Honorable Governor, and the duties of the Honorable Governor in relation to the bills passed by the state legislature and sent to the Governor they're all clearly laid down, not very clearly, Supreme Court made them clearer now. They were laid down in Article 200, and Article 200 says, passed by the state legislature comes to the Governor. Governor shall declare either that he accepts it, or that he withholds his assent, or that he is sending it to the President for the consideration of the President. This is all it says. In one case, it is not going by the advice of the council, that is on his own he does it, that is if there is a state bill which restricts the powers of the High Court of the state, then such a bill mandatorily has to be sent to the President by the Governor for the presidential response consideration. One case, in this case we have to understand what is withholding of assent. Governor assents, that means says yes. What does it mean to withhold assent? Withhold assent means the governor is studying the bill, will take some time, after which he will return the bill for repassage by the state legislature. So if you noticed, there is plenty of ambiguity here on the face of it, which is there is no time limit either to say I'm approving, assenting, or to say I'm studying and I'll return it to you, or to send it to the President. In this judgment, the Supreme Court lays down timelines based upon two expressions in Article 200. One says, the governor shall declare his response after receiving the bill passed by the state legislature. Shall declare. That means there is a sense of urgency there. He can't sit on them. He can't have a laid-back approach to it. Also, what is withholding of assent? As I said, there is a bill passed by the legislature, comes to the governor. Governor says, I'm studying it. I'll return it to the state legislature for repassage. I'm studying it. So while studying, he has two responses open. He can send it back to the state legislature or send it to the president. If he declares I'm studying, that is, I'm withholding assent, then he has to send it back to the state legislature. Otherwise, the option is he can send it to the president. So, the withholding assent, if he says I'm withholding assent, he has to send it back to the state legislature for repassage, after which it is binding on him. If he doesn't say I'm withholding assent, then either withholding assent option is open or sending it to the president also is open. So if he declares that he is withholding assent, only one option is open. He sends it, returns it to the legislature of the state for repassage, after which it is binding on him. Now the catch here is, none of the three options has a timeline built into it, spelled out by Article 200. And I have to also tell you, under Article 200, the money bill, if there is a money bill passed by the state legislature, sent to the Honorable Governor, he cannot return it. He cannot return it. He has to approve. He cannot return. And withholding assent, he cannot, because withholding assent has two parts. One is studying it, another returning it for repassage, after which it is binding on him. So in the case of the money bill, he can send it to the president. He can say yes, which is the norm, or he can send it to the president, after which the president responds according to Article 201. In one case, in Article 200, the governor on his own, irrespective of what the Council of Ministers says, has to send it to the president, which is a bill that is related to erosion of the powers of the High Court of the state. This is what Article 200 says. I want you to take a look at Article 200. Here it is. This is Article 200. I want you to see this. I want you to see this. See this. This is the basis for the Supreme Court verdict. Shall declare. It's as categorical as that. He has no choice. Shall declare is a strong word which says the governor should exhibit a certain sense of urgency about it, expediency, as soon as possible. If the governor says I'm withholding assent, then the governor, after sending it back to the legislature, after the repassage by the state legislature, it's incumbent on the governor to withholding assent. As soon as possible, he has to send. He cannot say, I'm withholding assent forever and ever. He is studying it. As soon as possible, he has to send it back to the state legislature. As soon as possible. Return the bill. If it's not a money bill, I told you the choices are saying yes, sending it to the president. Withholding of assent in the case of money bill is not allowed under the constitution. That's the constitution. So as soon as possible, shall declare. And in 1935 Government of India Act, in the related provision, there is this term discretion. And that term discretion has been deliberately omitted from Article 200, which is the counterpart of that provision in 1935 Government of India Act. So, discretion provision is omitted in Article 200. As soon as possible, he shall send it back to the state legislature and also shall declare. All these put together, the Honorable Supreme Court yesterday felt that we have to lay timelines for the governor to respond. Otherwise, there is a tendency on the part of the governor in some states that we have seen to take advantage of the silence in this article, whereby the governor is not told how quickly he should respond. So the Honorable Supreme Court said under Article 200, lot of things are said by the Honorable Supreme Court yesterday. What did it say? The governor does not have pocket veto. Pocket veto means sitting on a bill indefinitely without responding at all, because there is no timeline built into Article 200. Yesterday, the Supreme Court said it doesn't have pocket veto because the language of Article 200 shows that the governor shall act. Even otherwise, the norm is that when the legislature passes a bill on behalf of people in a parliamentary democracy, it does not pass a bill for time pass. It passes the bill because there is a sense of urgency about responding to the needs of the people, welfare, equity, investment, public order, whatnot. So the governor has to match the urgency. After all, I'll show you another article, Article 168, if we can have it, 168. What does Article 168 say? It says the legislature of the state consists of either one house or both the houses along with the governor. That is, the governor is a part of the legislature. That means the governor has to go along with the legislature. He cannot go against the legislature normally. And rarest of the rare, he has some discretion. Rarest of the rare. But that discretion in Article 200 is limited according to the Supreme Court, yesterday's verdict. How is it limited? There is no pocket veto. Does he have absolute veto? That is saying no. It's not there. Either say yes, or you have a suspensive veto. That is, send it back to the legislature. Legislature repasses it. And when it is sent back to you again, it's binding on you. You shall say yes, you shall assent to it. So, say yes, that is, the question of veto doesn't arise. Suspensive veto, returning it, repassage and binding on you, or send it to the president. In none of these, you have the option of absolute veto. There is no absolute veto. You've got suspensive veto. That's the only veto you have. No pocket veto. Indefinitely keep the legislature and the government waiting. No. Suspensive veto you have. Pocket veto, no. Absolute veto, no. And the only discretion that you have is you can take some time. How much time? Till the day before yesterday, we didn't know. Yesterday, the Supreme Court said that if the Council of Ministers headed by the Chief Minister under Article 163 tells you to withhold assent or send it to the President, you can take up to 1 month. Without them, you can take up to 3 months. And when you have to send it back, okay, the bill comes to the governor and the governor on his own thinks that it has to be repassed by the state legislature. In that case, take 3 months, send it back. After repassage, when it comes to you, let the governor not keep it pending beyond 30 days. That is 1 month. So 1 month, 1 month, 3 months, 3 months. These are the 4 timelines that the Honorable Supreme Court laid down, and that is what makes it landmark. So many aspects of this verdict that make it landmark. This is one aspect, timelines. Then the Honorable Supreme Court asked itself, is it required that we have to wait for the amendment to the Constitution for this? They said no. It is implicit in the language and content of Article 200 that there is time-bound behavior expected of the Honorable Governor, and so we are only filling the residual details. We are filling the vacuum. Residuary power the Supreme Court has. And what did the Honorable Supreme Court say? Since pocket veto doesn't exist, absolute veto doesn't exist, and the discretion is limited, let the Honorable Governor be bound by the timelines for which there is no need for any amendment to the Constitution. So Article 168 we'll come back to again. So what was the verdict of yesterday about? It's about telling the governor, you have a timeline to comply. Here is the timeline. And another big aspect that was decided yesterday was, see, when Tamil Nadu went to the Honorable Supreme Court in October 2023, the Supreme Court framed certain questions. They are, when you withhold your assent, what is the further course of action? Point number one. Point number two, after the repassage of the bill by the state legislature, what is the course of action you have to take? The governor has to take. That's point number two. When can the Honorable Governor send a bill to the Honorable President? What are the criteria? Should it be done only when the council suggests, or can it be done on the governor acting by the governor acting independently? So these are the questions. Yesterday, the Supreme Court clarified categorically, beyond any shadow of doubt, like never before. Apex Court was never this clear. What did they say? Withholding assent means take some time to return the bill for repassage, after which you have to sign, and of course 1 month, the Supreme Court said. And once the bill is returned, if it is substantively modified, then you have the entire cycle opening up. That is, you can again refer it to the president, or whatever else you want to do, you do. But if the bill that is sent back to the legislature is repassed by the legislature, you have no option again to send it to the president. The only option you have is within 30 days, the governor has to sign. That's been categorically said yesterday. So Article 200 has been substantively reinterpreted so that the real meaning in letter and spirit has been amplified and categorically clarified. So yesterday the Honorable Supreme Court said that the governor's actions of reserving some bills for the president and not signing upon the bills after the repassage by the state legislature is unconstitutional and illegal, and it invoked the extraordinary power of Article 142, in which it is said that the Supreme Court can take any action, give any order in order to render complete justice. So yesterday the Supreme Court said, we are invoking Article 142 to declare that all the 10 bills that the governor was sitting on even after repassage are declared passed. They become acts. When the government notifies them, Tamil Nadu government, they come into action. They come to be implemented upon. So that is about the 10 bills. What about the 2 bills sent to the president? Of which, in the case of NWT bill, the Honorable President said, I am withholding assent. So the Supreme Court said, since the entire focus is on Article 200, we are not going into Article 201 and the jurisdiction of the President related to a bill sent to him by the Honorable Governor for his consideration. They didn't get into Article 201 at all. They focused only on 200. But they said that any action that the President may have taken on being sent a bill by the Honorable Governor, that action is non-est. That is, it does not exist in the eyes of law. To be simple, it is invalidated. All action that the President may have taken is null and void, because the focus is on Governor and Article 200 and not Article 201. So Supreme Court declared under Article 142 all the bills in question to have been passed, point number 1. Said that the governor's conduct was unconstitutional, illegal, point number 2. And all that I said about Article 200, they have said so many things about Article 200, amplifying, clarifying, and injecting certain additional details, so on and so forth. It's certainly not judicial overreach, because they are only filling a void which is there in Article 200. They are not making separate laws for it. Does it require Article 368 and Constitution Amendment? Not at all. They said it's all inherent there, and they are only giving voice to what is silent in the Constitution under Article 200. Now, what is the plea, what is the grievance, what is the petition of the State of Tamil Nadu, the Government of Tamil Nadu in the case that they filed under Article 32 in October 2023. They said, here are the 12 bills, 10 that the governor is sitting on, 2 that is sent to the president. And not only that, which is Article 200 jurisdiction. Article 163 is also brought in here. The advice that the council headed by the CM gives to the governor is binding on the governor except when the constitution expects the governor to act in his own discretion. That is Article 163. And in that, how is that relevant here? It's not a bill. Of the 4 matters that were brought to the Supreme Court in October 2023, 1 related to the bills. The other 3 are about the advice given by them under 163 not being acted upon by the Honorable Governor. Regarding what? Some mercy petitions he had to decide, he did not, he sat on them. Some appointments he had to make on the advice of the Council of Ministers, he was not making. So these are 163, Article 163 related advices. In that context, the Honorable Supreme Court said, Article 168, he is a part of the legislature. He has to complement the legislature, complete the legislature, not be a roadblock to the legislature. He has to build consensus. He has to look for resolution. He cannot be a foe. He has to be a friend, not just friend, philosopher and guide. That is the role that the Supreme Court gave him yesterday. All that flows from Article 168, wherein it is said he is a part of the state legislature. If he is a roadblock, he is violating 2 principles. The principle of parliamentary democracy, where the elected government is the real head of government, that is the head of government, that's where the power is. And also federal principle, where central and states have to work together. The governor cannot take up a political position in favor of the center. On the face of it, looks like he is acting as an agent of the center, and acting as an agent of the center, he can't be seen to be weakening the state. Whether that's an intention or not, we are not here to judge. But the fact remains that the governor has to be a link. Governor has to join them, the center and state, not divide them. He has to bring them together. So that is what the Supreme Court said yesterday. And the basis for them to say this was Article 163, where except in rarest of the rare cases, the discretion of the governor doesn't come into the picture. And also Article 168, under which the governor is a part of the state legislature. And we talked of Article 32. How are the fundamental rights violated? The action of the governor is arbitrary. The action of the governor leads to denial of human rights, fundamental rights, right to life, and so on and so forth. And if you don't appoint the vice chancellors, what are the 10 bills about? Keep the governor as the chancellor of the university, state universities, but the power of appointment and dismissal of the vice chancellor should be given to the state government headed by the CM, the Council of Ministers. So appointment and sacking of the VCs should be the power divested from the governor, even while retaining the governor as the chancellor. This is the substance of the 10 bills that the Honorable Supreme Court declared passed by virtue of the power it invoked, built into Article 142. Complete justice you have to do, so you can pass any order. So that was the verdict, and 32 fundamental rights. But Article 361 says that no mandamus can be issued to the president or the governor for the discharge and the manner of discharge of the official duties. There is no writ issued to the Honorable Governor. There is another, point number 1. And nothing was asked of the governor. The Supreme Court did the work on its own under Article 142 because it could not tell the governor to do it, because under Article 361 that is barred. So we have seen 32, 361. And 111 is about the presidential veto powers. There also identical language is used. What is the language? After the passage by the parliament, when the bill comes to the president can assent, withhold, assent. These are the only 2 choices. Withhold means I'm studying, after which returning, after which I shall abide by the repassed bill. Only 2 choices they have. And this will also clarify Article 111, the veto powers of the Honorable President, where pocket veto could be outlawed, absolute veto, even otherwise it's not there, and timelines for the President. This judgment is about the Governor. Governor is President in the mirror. So, yes, it will apply to the President, but that's not the focus presently. And we can also see Article 111 here. And at the end of it, we should see the Governor takes the oath under Article 159, wherein he says he'll preserve, protect and defend the Constitution, and he'll work for the well-being of the people of the state. Accordingly, he should go with the legislative decisions, legislative mandate expressed through the decisions, advices of the Council of Ministers. 163, 159, 168, they all have to be read together. So yesterday's landmark verdict clarified on all these matters. We'll see the rest of the graphics. 111. Here is the 111. The President can either. That is, it's got only two. Either give assent or withhold. Withhold means send it back to the Parliament, unless it's a money bill. Because again, the money bill, you can say, in the case of the President, what is it that the President can do in the case of money bill? He can say yes, and he cannot return. He can only say yes in the case of the money bill. He cannot return. If it is not a money bill, withholding assent means he can return the bill after repassage. It is incumbent upon him to sign. But in the case of money bill, that option is not there. Neither can he return. Rejection is ruled out. So he can only say yes in the case of the money bill. Yes, that is the Constitution. So that's it. Only two choices he has. Next article, 201. So here you are sending it to the President. This is a little tricky. What choices does, in the case of money bill, you can send it to the President. What are the choices for the President? He cannot return it. He can say yes, that's all he can say. He can say yes, that's all. Withholding assent is not possible in the case of the money bill. So there is a bill sent to the President, and the President can say yes or withhold assent, which means, like in the case of the NEET bill, comes back to the Governor, State Legislature, repasses it within 6 months. That is the rule here. Within 6 months. And after repassing, it goes again to the President, and the President has no obligation to sign. This process can go on and on and on. To what extent this article remains as it is, what sort of a shadow Article 200 casts on 201 and also 111, we have to wait and see. Only the judiciary can explain, but the President not being in focus, we may not see clarity about 201 and 111 anytime soon. This is 201. Then, Tamil Nadu. We have seen Tamil Nadu. This is what the Supreme Court said. Take a look at it. Article 200, whatever the Governor does is open to judicial review. That's been stressed yesterday also. Non-est, I told you non-est. Non-est is a Latin term which says it doesn't exist in the eyes of the law. Next, Punjab. See, on the 10th of November 2023, Honorable Supreme Court gave this verdict that withholding assent under Article 200 is that study it and return it. Repassed, you have to sign on it, and all this has to work in reasonable time as soon as possible. You cannot take forever and ever. On the 10th of November, the verdict comes, and within 10 days, the Honorable Governor of Tamil Nadu sends 2 bills to the President of India and the others to the state legislature. And after repassage by the state legislature, he is still sitting, and that is because there is no time limit. But yesterday, the Supreme Court declared all of them passed, and they are all acts now. So this is the verdict. This is the verdict which has been amplified, clarified, and given a decisive shape yesterday in the Supreme Court verdict. Next, oath of the Governor. Please ask for the PDF. It is there. It will be on the website also. That's all we have about the judgment. All the best.